Yeah. Unit 3, Marriage Law Reforms. Major portion of the statutory personal laws enacted in the various Muslim countries represent a mere codification of the established established law or, at best, unification of hitherto divergent legal principles. There is, however, no reason to deny the fact that the certain provisions in these laws have introduced significant reforms in the traditional law. The principal reforms so introduced in in one country of another relate to marriage, age for men and women, and different or age between parties to marriage, role of marriage, guardians in the fixation and solemnization of marriage. Registration and documentation of marriage, monetary aspects of marriage, dowry and expenses, polygamy and right of co-wives, maintenance of wife, family and matrimonial, home during of substances of marriage, unilateral divorce, right of parties to marriage and grounds for judicial divorce, post post divorce relief for the parties, especially for women, period of gestation and its implications, parents' right relating to custody and guardianship of children, especially for mothers. Uh, inheritance right of certain close relatives, surviving spouse, daughters, brothers, sisters, grandfathers, and descendants of predeceased children, choice of the legatee, especially their eligibility to receive a bequest, and validity, tenure, and management of family wives. Reforms in this areas have been effective. Different reforms in different countries, either under the provisions of comprehensive codes or laws, of personal status or family right, or by way of sporadic legislation. The source material the source materials for the for all the aforesaid reforms have been located by the jurists and legislator of the Muslim world in the depth, divergence, flexibility, and richness of the legal principle within the vast framework of the Sharia. It is nobody case in the Muslim states, including Turkey, that personal law has been codified and reformed merely to modernize or westernize the law. Nor have their architects, advocates, and exponents ever quotes any holy and Islamic source for any of these reforms. The motives behind of the objects of all this legislative activity have been, as taught by the reformers, the need to systemize personal law on the pattern of others' laws since codified. The desire to benefit from lesser known and hitherto neglected principles and juristic opinions within the fold of the Sharia. The will to check misinterpretation, misapplication, and growing misuse the Sharia law of of which there were greater chance and possibility in its uncodified state. The police is nationalizing, and surely Islam is seeing the law and the arts to rebuild the society in conformity with the original unadulterated socio-legal principle is of Islam. In several countries, the ulama have approved or have been closely associated with the reforms effected. At the same time, some of the reforms in some countries have been opposed and criticized criticized by certain sections of religious leaders and scholars. This has happened in Iraq, Indonesia, Pakistan, Tunisia, South Yemen, and Turkey. On some occasions, their objections were accepted and the reforms proposed on or already effect, dropped, repealed, or modified. Main source Tahir Mahmud, 1987. Personal law in Islamic countries, history, text, and comparative analysis. Academic of Law and Religion, New Delhi, pp. 11 until 30.